Right, good morning. Welcome to all of you who logged on online. It's nice to have you with us. I'm Bruce Robertson, and on my left is Alan Rycroft, for those of you who don't know us. There are two parts to our webinar this morning. Alan and I are going to chat to you about some of the recent amendments to labour legislation. Alan's going to cover the changes to the Employment Equity Act, and I'm going to cover the CCMA rules. There's no need for you to take notes. We will put up a video of this webinar and our workbook. We've got about a 50-page workbook that we're going to work through, and we'll put those up on WorkLaw in the next week or so after the webinar. So there's no need to take notes. You can access the material there. Can I also say, those of you who want to ask questions, we'll deal with questions at the end. Use the Q&A function. I think there's a Q&A function. Yes, there is. At the bottom of your screens, ask us questions if you want to, and we'll deal with those questions subject to time availability at the end of the webinar. Anything I haven't covered, Alan, that I think I should cover?
No, that's fine.
Okay, so let's jump right in. Alan, amendments to the Employment Equity Act that have come through recently.
Yeah. For many years now, the annual report of the chairman of the Commission of Employment Equity has complained about the very slow pace of transformation in the private sector. And the government has decided now to take some steps to try and speed this up. And so what we can perhaps just on the screen, oh, no, what's that? We're going to cover 4 points under the Employment Equity Act amendments. I'm going to talk about sector-specific targets. I'm then going to talk about compliance certificates. I'm going to talk about the deregulation of small employers, and then I'm going to just talk briefly about the redefinition of the phrase people with disabilities. So let's start in with the sector-specific targets. As you know, the Employment Equity Act has always required employers to set targets by which they can achieve transformation in the workplace, to achieve equitable representation of all people in South Africa in all job categories. These targets were set by employers after consultation, after drafting employment equity plans, and the aim was to measure compliance for each employer in relation to their own targets. Now, what the amendments do is to it empowers the minister to set specific targets for different sectors. The minister is going to establish, and I think there's been some considerable work done already on establishing national economic sectors. I've read, for example, Bruce, that the banking sector is already talking about these things. And then to set numerical targets for each national economic sector, and the minister can have different numerical targets and for different occupational levels, subsectors, or regions. So with the way it's going to happen, it's going to appear in the Gazette, and people are going to be given 30 days to comment on each sector target. Now, the significance of a sector target is that in the past, employers are guided by their own targets. These targets are incorporated automatically now, or must be incorporated into each employer's employment equity plan for the year. And they'll be measured on whether they meet not their own targets, but the sector's targets. Now, that might not be an issue for some employers who don't want to enter into any contracts with the state. But if you do want to enter into have some kind of win a contract, you must be compliant with the targets. So I'll come to that in a moment. I want to then move to the second point, compliance certificates. In order to be able to qualify to do business with the state, you have got to have a compliance certificate issued by the Department of Employment and Labour. And they look now at the following criteria: whether you're employed with your compliant with your national, your numerical target as set by the minister. If you haven't, what's your explanation? Have you submitted your annual reports? Have you ever had a CCMA or court order against you as an employer involving discrimination? And finally, have you ever failed to pay the minimum wage? Those are going to become the new criteria for a compliance certificate. Now, what's the implication of not meeting a sector-specific target? Some employers might say, I have no intention of doing business with the state. The significance is still this. The Director of Employment and Labour is entitled to check your employment equity plan. And if the director feels you're not doing enough to achieve transformation, the director can make a recommendation. And if you fail to comply with that recommendation, it can be made an order of the Labour courts, and it can be fines. Now, the fines are steep, 1.5 million for a first offence. So even if you have no intention as an employer of entering into contracts with the government, your performance is still being measured. Then moving to the third point, the deregulation of small employers. You might remember that until now, a designated employer has been defined as someone with 50 or more employees, or if your annual income reached a certain level. They're now going to treat all employers with less than 50 employees as non-designated and with no obligation to file an annual employment equity plan, to report annually. In other words, the complete deregulation of small employers. That's not to say there won't be some small employers who want to win contracts. If they want to win contracts, they must comply with the criteria. The last point I want to raise there, the people with disabilities. There's been a change to, so South Africa complies with a United Nations Convention on the Rights of People with Disabilities. And until now, the Employment Equity Act is referred to, is defined people with disabilities as people who have long-term or recurring physical, mental, or intellectual impairments. A new word has been put in there, sensory impairment. Now, sensory impairment is a term of art, and it means this term is used to describe deafness, blindness, visual impairment, hearing impairment, and deaf blindness. So there's no, I think, real impact, because I think those things were all covered already, but they're now made more explicit.
Okay.
So Bruce, those are the changes to the employment equity amendments. And I do want to say that while the President has signed off on this, a date for it coming into effect has not yet been given. And we on the Work Law will obviously notify subscribers as soon as we know that.
And we'll then obviously update our version of the Employment Equity Act online once those changes take effect.
Yeah, Bruce, the last thing I want to say is that these amendments and the Act itself, there's going to be some legal skirmishes here. Solidarity is about to proceed to arbitration in the International Labour Organization with the South African government, that the whole Act is discriminatory. And then other employer bodies are challenging these amendments, particularly on the right of the government to regulate targets for private sector employees. So there's some it's a lawfare ahead.
Okay. Can I just interrupt and say we've got a technological problem. It always happens, but we can't seem to get out of the screen share function. And I'm going to try some things. Alan, can you just pop next door and see on Carl's machine what everyone's looking at? But I'm going to end the show there. Okay, we seem to, I think I've succeeded in getting out of the screen share function. I'll wait for Alan to come back. He won't be a second. And it's fine. Yeah. Okay. Thank you. Our next, the next area that we're going to look at is welcome back, Alan. He does have some uses. Solves all the technological problems that we have. Our next area that we're going to look at are the amendments to the CCMA rules. These came into effect on the 24th of April. They were gazetted the previous Friday, so we didn't have much notice of this. The new rules are up on Worklaw, so you can access them. You don't need to be a subscriber. Those of you who might be out there who are not subscribers, you can access the CCMA rules on our website.
Can I just interrupt? To say that if you go to the CCMA website, the new rules aren't up yet, but the new forms are.
Yeah, okay. So the forms are up on the CCMA website, but you're going to have to access Worklaw to see the new CCMA rules. There's quite a lot of changes in those rules. A lot of them are procedural and administrative issues. So I'm not going to cover those. You can obviously look at the rules if you ever wanted to. I'm going to try screen share again. There we go. And we've done the employment equity amendments. Coming on to the CCMA rule changes. The first issue is that these amendments, broadly speaking, give a commissioner a wider discretion to deal with matters. And the first area is around condonation applications. Previously, a commissioner could only consider a late referral of a matter if there was a condonation application attached. And so most of our subscribers would be a respondent in these matters. You knew that if it was late and there was no condonation application, it wouldn't get past first base. That's now changed. A commissioner now has a wider discretion to deal with it. He can deal with it, he or she can deal with it by having a hearing at the hearing to determine how condonation should be dealt with, or order the party then to make written submissions. So the learning here is that you can't presume any longer that where a matter is referred late and there's no condonation application attached, that the matter won't be heard. Secondly, the question of postponing arbitrations, there are a number of aspects here. Previously, there was confusion often. Parties made application to postpone an arbitration, and they then presumed it had been postponed. There's a new rule that now says the matter will proceed unless you've been informed by the CCMA or the commissioner that the matter has been postponed. So it's making it clear that the matter is going to go ahead unless you've been told that it's been actually postponed. Secondly, then, a commissioner, previously, if the parties agreed to postpone a matter and they advised the CCMA in writing 7 days beforehand that it was going to be postponed, it was done automatically. Now, a commissioner is given a discretion, despite the parties agreeing that it's going to be postponed, the commissioner can decide whether to postpone it or not, and they have a discretion. Also, where parties have made formal application under Rule 31 to postpone a matter, again, the commissioner is given a much wider discretion. Previously, the commissioner could either postpone the matter without convening a hearing at all, or convening a hearing to hear the parties' views on whether it should be postponed. Now, the arbitrator could deal with it in any other manner he or she deems fit. I'm not sure what other options there are. I suppose the one I thought of is that they could actually reject the application without having a hearing at all, but that might have its own aspects of procedural unfairness. So there are a couple of issues there around postponing arbitrations, which give a commissioner a much wider powers. And then lastly, in the area of failing to attend arbitrations. Previously, if you were the respondent in a matter, if the applicant, the party who referred the matter, didn't pitch, the matter was dismissed. There was a Labour Court judgment a couple of years ago, Solomon versus Pokelo and Food Lovers Market, that challenged CCMA's jurisdiction to do this. They've now changed it. So where the applicant doesn't pitch, where the party who refers the matter doesn't pitch, the arbitrator now has the power to remove it from the roll. But He or she also has to do something to investigate or establish the reason for non-attendance. I don't know what they're going to do, maybe perhaps make a phone call to the applicant on the phone number that's on file to ask why they weren't present, and then the arbitrator has the power to reschedule the matter if there are good reasons. There's also a form that is now provided where you can apply to reinstate the matter on the roll. So there are a couple of changes there. Yeah, so I mean, I've been quite brief because they all largely of a procedural nature, but you can see that there's a wider discretion given to commissioners in those three areas. If you have any questions on this, please post them on the Q&A function and we'll deal with them at the end of the webinar. But for now, we're probably going to move into the case updates.
All right, shall I get going?
Yeah, get going, Alan, with the first case.
So these are difficult times for employers, starting with the COVID lockdown and now with load shedding. Employers are finding it very difficult to keep solvent, many employers. And to avoid retrenchment, two mechanisms are being used: short time and then also layoffs. And the first case I want to discuss is actually related to a layoff that happened because of COVID lockdown rather than load shedding, but the same principles will apply. So the employer in this case had a transport company, and he had obviously couldn't offer any work during that period and laid off this particular driver almost indefinitely. They said they would reconsider in 3 months.
So Alan, just to check, you're talking about unilateral layoffs.
Yeah,
So, obviously, if it's been agreed, that's fine.
Yeah, I mean, there are many collective agreements where layoffs are regulated. This is unilateral. What's interesting about this, the employee went to the CCMA and at first described the layoff as an unfair dismissal, and then changed it to unfair labor practice. Now, this is a case really about how you can lose a case if you frame it wrongly. So it went into the CCMA as an unfair labor practice. Now, and the employee was relying on that part of the unfair labor practice definition, which talks about an unfair suspension. And the CCMA Commission said, yeah, that seems to fit. And so ordered reinstatement. When it went on review to the labor courts says, no, that phrase, unfair suspension, is a reference to disciplinary suspension. A layoff is not a disciplinary suspension. And the court said, actually, this doesn't really fit into unfair labor practices at all. And because you framed your dispute like this, I'm afraid the CCMA didn't have jurisdiction. The court contemplated, and maybe you could put it on the screen, because various options so the point I'm making is the nature of the dispute is the important thing. So is it an unfair dismissal? Just want to deal with that. And there are some cases already particularly where labor brokers, a contract has ended, and all the people who are being used by the labor broker for that contract, they've got no more work, and so they are laid off. Now, already our courts have said that is an unfair dismissal. All right, so that is one way to frame it. The second one is the unfair labor practice, which, as I've said, this recent case has said is not viable as a way to frame the dispute. The third way is to treat it as a unilateral change to conditions of employment, which we still want to say, we talk about unilateral changes. Section 64(4), you might recall, is this section in the strike legislation part of the Labour Relations Act, which allows employees who are affected by unilateral change to get a status quo order. Things must be reversed. Unfortunately, very recently, the Labour Court has said that is not available to an individual employee. It's something which employees as a collective can use. So it leads to the only other possibility for a single employee, but also to a group of employees, to rely on Section 77(3) of the Basic Conditions of Employment Act, which gives the Labour Court power to hear any matters arising out of the contract of employment.
Yeah. I mean, just to add there, Ellen, I mean, we've been talking about unilateral layoffs through, load shedding and COVID and so on. But we often get asked through our helpline about what is the remedy for an individual employee to dealing with unilateral changes to terms and conditions of employment. Equally, even a group of employees who don't want to contemplate strike action under Section 64, what is their avenue? As you know, our Labour Relations Act creates clear paths for unfair dismissal disputes, unfair labour practices, unfair discrimination disputes, but there's no obvious path for a unilateral change to terms and conditions of employment. And attention was drawn by a labour arbitrator the other day to the Section 77(3) of the Basic Conditions of Employment Act, which gives the Labour Court the power to deal with issues arising out of contracts of employment.
Yeah.
So we do think that this is probably the avenue that parties would have to use.
Yeah. I also want to just mention that the Unemployment Insurance Act has been amended, what was it, a couple of years ago. Until now, you had to be unemployed before you qualified for the benefit from that act. The amendment allows you to claim unemployment insurance payout, the benefits, if you have had a shortage, less hours of work.
Yeah.
So I think what employers could do is to facilitate the claim with you with unemployment insurance.
Just, Alan, talk to us briefly about when these circumstances, which have led to a layoff, either through COVID or through load shedding, could this ever constitute impossibility of performance which negates the employer's obligations to comply with contracts of employment?
Yeah, well, can I say that it is possible that an employer cannot, it's actually impossible for the employer to offer work and pay for it, pay for the work that's rendered, the labour that's rendered. But the Labour Court during COVID said that force majeure, which is the French term for impossibility of performance, that it is a very high standard. It's not just financial inconvenience or financial hardship for the employer, it's got to be
genuine impossibility of performance.
So I don't think that's, but I want to say that on certain facts, it might be possible to use that as a defense.
And the example that you're referring to in that Labour Court case, it was a restaurant that couldn't have tables and couldn't serve meals, but they could have sold takeaways.
Correct, yeah.
And so the court said, well, yes, there was economic hardship, but there wasn't impossibility of performance in that case.
Yeah.
Yeah, just a useful comment there. I don't know.
Inside,
Where?
Yeah.
Oh, okay. Alan's just drawn attention to where the obvious screen was. Maybe you should do that again next time. The next case that I'm going to chat to you about deals with the case of employer liability for harassment. You might be aware of Section 60 of the Employment Equity Act. It's been used on a number of occasions in the last year or two, where the employer is made liable for harassment that's committed at the workplace from one employee on another. So Alan harasses me, as he often does. I'm victimized. I can now sue work law for damages or compensation arising out of the harassment that Alan has constituted against me. Now, let's look at some of the judgments, because this is an important issue for how you deal with harassment allegations at the workplace. There's an arbitration award in the last year or so that awarded 200,000 Rand to the victim, to the employee against the employer. There's a ShopRite Checkers judgment. Labour Court ordered 25,000 Rand. there's a Labour Appeal Court judgment that actually overturned a Labour Court order which had awarded the employee 150,000 Rand damages. And there's a recent case involving the SAPS where a Colonel Oosthuizen was awarded 300,000 Rand by the Labour Court under this section. So let's talk about that last case, this Oosthuizen versus SAPS case. The effects are interesting, and they might expose to you or highlight to you when an employer might be liable for this kind of harassment. She was a colonel and an HR commander in the SAPS. She was a white female, and she had two subordinates, both warrant officers. They were both black males, and they accused her of racially abusing them. And the facts are these: there'd been an altercation between them over action that she had taken against them at the workplace. She was giving them instructions, and they alleged that she had used the K word in her dealings with them. They lodged a crimen injuria criminal case against her. They lodged internal grievances. They demanded that she be transferred pending an investigation. Events then took a turn with an SAP intern who reported that she'd overheard the warrant officers colluding and conspiring to falsely accuse her of calling them using the K word. So the colonel then opened her criminal case against them, opened a case of crimen injuria and so on, and lodged internal grievances against them for making false allegations. But the colonel was transferred pending the investigations, while the two warrant officers were left in their places. The facts get quite complicated, so I'm not going to take you through all the facts, but basically the SAPS did not deal with the matter in a fair manner and in an even-handed manner. And the SAP favored the warrant officers' version, even though ultimately a criminal case was found against them, which then ultimately led to these two warrant officers being dismissed. She lodged a claim of victimization, harassment. They ended up at the Labour Court, and the Labour Court heard the case and found that there was no evidence to show that the SAP had consulted all parties as required by the Employment Equity Act under Section 60 once harassment was alleged. And worse still, the colonel was unjustly condemned for lodging her grievances against the warrant officers. There was no evidence to show that the SAPS took the necessary steps to eliminate the racial harassment. Instead, they acted in a partial manner by protecting the perpetrators at the expense of the victim. And there was no evidence to show that the SAPS did all that was reasonably practicable to ensure that the warrant officers would not racially harass the colonel in future. So the Labour Court ordered the employer, the SAP, to pay her 300,000 Rand damages and to apologize in writing to her within a week of the court order. So these cases are complex. They often involve he said, she said kinds of, or it might be he said, but or else he said, she said in a sexual harassment kind of case. So how does the employer deal with these? And how does the employer minimize its potential for liability under Section 60? Let me share screen again. I'm going to pull you up a slide where we deal with some of these points. Steps to minimize the employer's liability. Firstly, have a harassment policy in place with clear dispute procedures, which sets out an informal procedure and a formal procedure as to how the matter should be dealt with. Respond quickly to allegations. The Act Section 60 says as soon as these allegations are made, you must consult all parties. And you've got to act in a manner, there might be two versions being given to you. And at that stage, you don't know which version might be the truth. So you've got to take action in a manner that allows the possibility, perhaps, of either party being true and not creating an inherent bias in favor of one or other of the parties. So take preventative measures to prevent any further victimization or harassment taking place. Provide employee assistance. The Act and the Code of Good Practice, which I'll talk about just now, talks about counseling, help with counseling, possibly additional sick leave, etc. Avoid an inherent bias. Don't just believe management's version or against the employee's version. And base your be guided by the facts in taking the action. So when you've done an investigation, allow the facts as they emerge to determine what follow-up action is necessary. And lastly, comply fully with the new Code of Good Practice. There was, as you know, as we published this on Work Law on a number of occasions, there was a new Code of Good Practice on harassment that came into being in the last year. You need to understand all the employer's implications under this Code of Good Practice. Can I also mention, we put up a draft policy, harassment policy on Work Law under the precedents section on Work Law, and there is a draft harassment policy for those of you who don't have a harassment policy. So that is something that you might want to have a look at. We give clear guidance and instructions on how you can amend this to suit your circumstances. We also currently in the process of compiling a training video because the Code of Good Practice talks about ongoing training and conscientizing your workforce. And we're going to, in the near future, have a training video up on Work Law that you might find that you want to use.
Bruce, I can just say, just to emphasize it, a lot of employers might be, or subscribers listening in, might say, oh, we've got a sexual harassment policy already. I think we must be clear that the new code deals with 3 kinds of harassment. It's sexual harassment, racial harassment, and bullying. And what the new Code of Good Practice requires is that employers must have a policy dealing with all 3. So I think it makes our draft policy a useful tool.
Yeah. Alan, that's not a useful slide because that ends the slideshow completely. Okay. So show the taskbar.
Just go to the next slide.
Okay, I'm going out of the show.
Okay.
Stop screening. Okay. Let's move on. Okay, next case.
The next case deals with fixed-term contracts. And what happens when an employee is allowed to carry on working after a fixed-term contract has expired. Now, I think this is fixed-term contracts seem to be a feature, particularly of the public sector. People like municipal managers and that kind of ranking in government are all signed up for a 5-year contract, it seems. And the question is, what happens when they're allowed to carry on working? Well, the case that I'm talking about, it involved 4 employees at a provincial level in the legislature in Gauteng, who had, for over a period of 10 years, been given renewed contracts in between, allowed to carry on working between the next contract and so on. And then finally, after 10 years of work and these fixed-term contracts, they were told that we are advertising these posts and you must apply. They took that to be an unfair dismissal. And so the issue to be decided was, what's the implication for an employee who's allowed to carry on working after a fixed-term contract has expired? Both the CCMA and the Labour Court reached a conclusion that if an employee is allowed to carry on working after the expiry of a fixed-term contract, they're then employed on an indefinite or permanent basis. When this got to the Labour Appeal Court, they said that that was not a reasonable finding in the light of the facts of this case. And what this case says is that the mere fact that an employer continues to work in the same position for the same employer after his fixed term contract has come to an end does not mean that this fixed term contract morphs into a permanent employment. And it also means that there isn't one of indefinite duration. But this, I will see our second point there, it depends on the facts in each case. There could well be a situation where I think they could have reached a different conclusion. The case deals with the idea of a tacit contract having been developed, and the Labour Appeal Court said to prove a tacit contract is a very, very difficult thing. I'm not going to go into the technicalities, but if it might apply to you, then you could look at this case to see what is required before there is a tacit contract and a fixed term contract's turned into permanent employment.
Our next case also deals with fixed term contracts, and it deals with what is the appropriate remedy when a dismissal is found to be unfair, but at the time that that ruling is made, the fixed term contract would actually have expired. This is, again, it's a Labour Appeal Court case. So what is the appropriate remedy in that case? And I mean, have a look at the facts of this case. This is this Labour Appeal Court case that I'm talking about. Employees on a series of fixed term contracts. The last one was from a period August 2015 to October 2015. So bear those dates in mind. During this period, during August to October, the period of the fixed term contract, the employee was dismissed for negligence. This, I'm not going to bore you with all the facts, but this was subsequently found to be unfair by the CCMA. The CCMA case was heard after October 2015, i.e. after the fixed term contract had now expired. So the commissioner said, well, it was never the employee's case. They haven't put evidence before me that but for his dismissal, the fixed term contract would have been renewed, and no evidence was made that there was any expectation of continued employment beyond that. So the arbitrator awarded compensation. And the compensation that the arbitrator awarded was the income that the employee would have earned for the balance of the fixed term contract had he not been unfairly dismissed. And that amount, it was 2.5 months' pay, which came to about 37,000 Rand. This was taken on to the Labour Court. The Labour Court said, no, this person was unfairly dismissed. They should be reinstated. This was appealed to the Labour Appeal Court, and let me find the screen for you. It was a Toyota case, Labour Appeal Court, and the Labour Court said only where the original contract would still have been in existence, but for the unfair dismissal, could you reinstate someone into that fixed term contract. Otherwise, the appropriate remedy is compensation. So the Labour Appeal Court agreed with the arbitrator and overturned the Labour Court order. The Labour Appeal Court said that the Labour Court's reinstatement order created a permanent contract of employment between the employer and the employee when no such contract existed. Since reinstatement involves the original contract of employment, which in this case was one of limited duration that had terminated by the effluxion of time, it was legally impermissible for the Labour Court to create a new contract through ordering reinstatement, and the appropriate remedy was compensation. So those of you who are at the in a CCMA case and you have a fixed term contract and a dismissal during the fixed term contract is found to be unfair, you should draw this case's attention to the commissioner involved to ensure that the appropriate remedy in those kind of cases will be compensation for the balance of the fixed term contract and not reinstatement into a contract of employment.
Which is, while you were talking, you said pay attention to the dates. And it struck me, you were talking about 2015, and this case was decided in 2023.
Yeah.
And so it's a theme I often mention is that if you are going to pursue matters through the courts, that's an 8-year delay in the finalization of what the final compensation was, 37,000. Hardly worth it. The legal fees would have far surpassed that.
Yeah.
All right, I want to now talk about on something on a different theme. I think most people over the years have got to know the code of good practice on dismissal quite well. And you might recall there's a simple paragraph describing the bare essentials of what procedure must be followed. It goes like this. Normally, the employer should conduct an investigation to determine whether there are grounds for dismissal. This doesn't need to be a formal inquiry. You've got to notify the employee of the charges. You've got to allow an opportunity to state a case. And must allow the assistance of a trade union rep. And after the inquiry, the employer should communicate the decision taken. Now, since that time of this code, which dates back to 95, employers have had their own disciplinary codes, and they're far more elaborate. They require all kinds of procedural steps. In this case, the employer had that exact paragraph as its disciplinary procedure. And so this case involved a security security officer who observed the loading of equipment onto a truck and didn't report this, causing a loss to the employer of some 150,000 rand, and she was dismissed for the dereliction of duty and for not reporting what was obviously a theft. The employer told her what the charges were, dereliction of duty, asked her to make representations, and she made some representations in writing, and the employer considered those and then reached a conclusion. So that was probably over in a few minutes, you see. And the employee was quite shocked and took them out to the CCMA, who was scandalized by this and called it a sheer, repulsive, repugnant travesty of the principles of procedural fairness. Now, here's the surprise. It goes on to the Labour courts. And the judge says, actually, if you comply with the code of good practice, as this case did, well, it can't be wrong. And said, sure, it was a very abbreviated procedure, but if you do that, it's not a wrong procedure. Now, I can imagine a lot of you listening to this case must say, wow, that's a nice way to go.
And you've seen quite a lot of articles in journals about saying the end of internal inquiries, no longer a need to hold internal inquiries.
Imagine the appeal of saying, which you charge of this, make some representations, why you shouldn't be dismissed. Oh no, we find you are dismissed, goodbye. It's very appealing. But we at WorkLaw are not going to recommend that for a number of reasons. The first reason is that we think that there is a real benefit to having a case exposed with a neutral chairperson. That writing down your version of something doesn't communicate everything about the matter. You might be, also, it could be someone who's not comfortable writing a version. Somehow something being aired through oral evidence.
And there's no challenging to the evidence.
No, correct. So we think that there's a better chance of things emerging as the truth if you had we now think of as a normal disciplinary inquiry. The second thing is we think is that this will reduce the number of disputes referred on to the CCMA. If you go this very abbreviated route, we think employees will invariably think, I've been treated unfairly. And then the third thing we think is that it takes a long time to change your disciplinary procedure. You can't unilaterally change a procedure without some kind of consultation at least.
Yeah, so those employers who were thinking of going this route, well, if you're bound by an agreed procedure, you can't just change that. You'd have to get agreement to change that, which is highly unlikely.
Yeah, and another thing I want to say, this Miani's case was based on the facts of that case. In that case, it seems as if that security guard did not want to call any other witnesses.
Yeah.
If you simply have got to send in your version in writing, well, where does the witness fit into this? And who's going to lead the evidence? So On the facts of this case, it seemed to be okay, but if you're denied the right to bring witnesses and for them to be cross-examined and so on, then I think there would be procedural unfairness.
Yeah.
So I think we would conclude that even though there's been, for some years now, the Labour Court has been saying, please be informal, don't adopt the criminal law method. We still think that there's a real role for having a simple, fair hearing.
Yeah. And as per Avril Elizabeth Holmes, it doesn't have to be over formalized, doesn't have to be overly complicated. Basic principles of fairness.
Yeah.
At a hearing.
Yeah.
Yeah.
I think I'm speaking about the next steps as well. Now I want to talk about the drafting of disciplinary charges. Quite a number of helpline queries to us are asking for assistance on how to draft disciplinary charges. And I think the lessons come through a number of times in cases we referred to in our newsletters, is that you should try and describe what's happened rather than give a name to it.
Or give a sort of technical name,
Yeah.
like criminal law label.
Like fraud.
Yeah.
In the case that I want to talk about now, this is what happened. There was seemed to be some insulting language, and the guy pulls another guy's T-shirt, and there's insults on a level, that kind of thing. The employer decided to charge the person with assault. Now, the word assault has got a particular criminal law meaning. He said it's true, if I just touch Bruce like that, it could be regarded as assault. But I think you know that the workplace context, assault's got a meaning of physical fighting. So this case is one which resulted in the courts. Look, although the Labour Court finally said that the decision of the Commissioner and the Labour Court was within the bounds of a reasonable decision, it did say this was really, the party should really have described this in the language, in much less formal language. So there's no need to label or compartmentalize the charges, set out the facts and explain the complaint that is the subject of the inquiry. They suggested it was far better to have just talked about this as being aggressive behavior or aggressive grabbing of a T-shirt rather than using the assault word. I also just want to say, we also in the last year have put up a case where a bank employee, she was charged with dishonesty. Mm. What she did was highly irregular, but it wasn't dishonest.
I mean, she paid her own money into customers' bank accounts.
She took 100 Rand of her own money and put 10 Rand into 10 accounts.
To keep the accounts active, because she was, part of her performance was measured on how many open accounts she had.
So it benefited her not financially at all. And she was quite open about it.
She was open about it.
She told supervisors.
And she actually spoke to her boss, and she said this is a great idea to keep accounts active.
And in this case, we went through all the way to the Labour Appeal Court, who also said this wasn't dishonest. But I think our comment is, look, it was a real irregularity for a bank manager to take her own money and put it into 10 accounts. And
we have a number of banking houses who subscribe to Worklaw. We've asked each one of them, would they employ a bank manager who does this kind of thing? And you can guess what the answer was in each case.
Yeah, so I think it's always good to just, when you're drafting the charges, to say you're charged with misconduct in that on this day this happened, and leave it up to the chairperson to assess whether that behavior constituted misconduct.
We're jumping to a new issue, and it's an issue of testing positive for DACA. And we've raised this before in webinars, but the cases on this keep coming in. And it's this potential conflict between being under the influence versus testing positive. Alan will tell you from firsthand experience that regular users of DACA, it stays in their system for a considerable period of time. Someone might have used DACA 10 days ago, and yet they'll test positive in a drugs test. Are they under the influence? Because all our occupational health and safety legislation talks about being under the influence. Most of employers' codes of internal policies and codes talk about being under the influence. Is the person under the influence? No, they are not impaired at all in the performance of their duties. Yes, they're testing positive for DACA. How do you deal with this? I'm going to just pull up a number of cases in which this has been referred in the last year. The first is this Eneva versus Barloworld equipment case in June of last year. And you know, obviously always the facts of cases become important. But this person, she was a regular user of cannabis or DACA. She argued, and she was dismissed for testing positive. It was common cause. It was accepted, admitted, that at the time of undergoing her test, she was not impaired in the performance of her duties at all. She was not under the influence. Yet she was a regular user of cannabis for various reasons, health reasons, she claimed, etc. And the Labour Court, it's an interesting judgment because the Labour Court accepted that unlike alcohol, which leaves an individual's bloodstream within a few hours, cannabis can remain present in an individual system for a considerable period of time, and one cannot determine a level of impairment based on the cannabis test. And the court called for, these are the words in the judgment, these are not my words, a scientifically validated test to assess if an employee is stoned at work and is thus liable for disciplinary action. So those are the words of the judge in the Labour Appeal Court case. And as far as we know, there is no scientifically available test at this point in time that can test levels of impairment for cannabis or DACA. I know there is a saliva test, which is apparently more accurate than a blood test, but it still picks up past usage and doesn't test for impairment. However, notwithstanding having expressed those concerns, the Labour Court found in that case that despite her use of cannabis not having affected her performance at all, she was unfit to render her services as a result of continuing to test positive, and they confirmed that her dismissal was fair. The next case is a NUMSA case, PG Glass, in December of last year. And again, the court accepted that cannabis testing positive does not demonstrate a degree of impairment, but the court, strangely enough, went on to say that proof of impairment is not required, as it is automatically assumed that one is under the influence of cannabis due to its intoxicating nature, which quite honestly doesn't make any sense to me at all. Having admitted that or acknowledged that a test for cannabis doesn't demonstrate the degree of impairment, to then go on to assume in the next breath that proof of impairment is not required, as it's automatically assumed that one is under the influence. Just really, to be honest, it doesn't make sense to me. And that, oddly enough, that quote out of that judgment has now been used in other judgments to substantiate the outcome that the court has come to. I think this case was not argued well by NUMSA. They went off on a tangent trying to argue that the Constitutional Court had decriminalized DACA, because it isn't a drug, it's a plant or a herb. So I think that case was badly argued by NUMSA, and they didn't draw clearly the distinction between impairment and testing positive. The next case is in fact a Labour Appeal Court case involving SGB Cape Octarex versus the MERBC, heard in October of last year. And again, this principle wasn't, or this conflict, this issue that we're talking about, wasn't clearly dealt with in that case, because here, in fact, whilst the employee was charged with testing positive, the employee had actually been caught smoking DACA at work. So clearly the person was in breach, so the outcome shouldn't have come as a surprise to that person. So there is a problem here, we think, even though every judgment that we so far have come across, apart from one arbitration award that we're aware of, which is on the work law site, which said that the person wasn't impaired, therefore the dismissal was unfair. Every other court judgment that we're aware of thus far has equated testing positive for DACA for being under the influence.
Bruce, can I ask you this question? If an employer has got a rule in their disciplinary procedure which says testing positive is a dismissible offence, zero tolerance, is that a fair rule?
Well, you've raised the issue in your last question. Certainly, employers can have a zero tolerance policy, but as you know, there have been other court judgments that have said rules have got to be fair, they've got to be reasonable, and if the real issue is impairment, and you have a rule that says testing positive is automatically grounds for dismissal, I think it can be argued that that's an unfair or unreasonable rule.
Yeah. I think employers would have to argue that their obligations in terms of Occupational Health and Safety Act to keep safe employment, a safe working environment, might be something which is a factor which should be respected over and above individual rights. I don't know.
And maybe in the absence, but there's a clear need, as I put up on the screen, for a scientifically validated test to assess levels of impairment.
Yeah.
Because clearly what we're saying is if someone's ability is impaired, if they're under the influence, they're clearly grounds to take action.
Yeah.
So employers would be at ease to know that every judgment thus far has gone in their favor when employees have tested positive. We do think this point might be succinctly argued at some stage in the future, and the distinction might become apparent. Employers who want to wear belts and braces, maybe if there is a positive drug test, they should do a second test to test levels of impairment, and use all the old practical means that you use to determine whether someone is under the influence or not. Are they behaving abnormally? Is their speech affected? Is their conduct at work affected? And that evidence, coupled with the positive test, will surely be substantiation of a need to take action.
Yeah.
Unfortunately, I'm sharing my technological irritations with you. At the top of my screen, I'm losing the ability to get out of the shared screen function, and I've got to end the show on each case, which brings us back, but I've then got to create the show each time we go back into a slide. So I'm just sharing my technological frustrations with you at this point.
I'll have Bruce tested properly. I want to talk about team misconduct. And for this case, I want you to picture a big store that actually involved Ashfield and Clarksville. But if you can imagine a builder's warehouse size shop, huge. What the employer started to notice was that there was huge shrinkage. It started off at 4.7% of sales. That would start off at 21,000 in a month. We climbed up to 24. Next thing was 88,000 in a particular month, and it was really alarming the employer that stock was just leaving the shop without being paid for. So they did various things. They had a shrinkage workshop, and then they offered to have an anonymous tip-off system. And then when there was no improvement at all, in fact, it got worse, they gave the entire staff a final written warning for what was team misconduct. And then when the shrinkage the next month was the worst it had ever been, all the staff were dismissed. Now you can imagine, I don't know how many staff there were, but you can imagine it was a huge number in a shop like Cashbuild or Builder's Workhouse or Workshop. So you might be interested in the charge, because that's what does team misconduct look like. They were charged with it as individual components of the group. Each culpable failed to ensure that the group complied with a rule or attained the performance standard set by the employer. And So it's a strange kind of charge. You charge as an individual because you were culpable for not allowing the shrinkage to arise above a certain percentage.
So you charge as part of a team.
That's right.
Okay.
So the Labour courts felt that the time of dismissals fell within the bounds of reasonableness. But at the Labour Appeal Court, there was a far greater scrutiny given to what the employer had done. It said there was no evidence.
Sorry, I've just got to get through these points. Just give me a second.
There we are.
There we are.
The Labour Appeal Court, there was no evidence that there was any systematic controls, no cameras, and in a huge shop like Builders Warehouse or the shop build, cash build, there were people who were working far from other people, and it was wrong to regard someone who works this end of the shop as being culpable, have the same level of responsibility as someone over there. They had no systems, and so the requirements for team misconduct, there must be sufficient grounds for inferring that all the employees were indivisibly culpable, collectively responsible as members of the team for misconduct. But this is going to really require evidence. You can't just have guilt by association. You're going to have to show that someone working in this side of the shop must have known about what was going on elsewhere. So
I mean, it's very hard for an employer to prove team misconduct. You've got to lead evidence then, as I understand it, Alan, to substantiate why each individual members of those teams are collectively responsible for the team's output.
See, I think if they asked for where's the documentary evidence, there was not even any evidence to show which stock was being stolen.
Yeah.
And if it was shared right across the store, well, that might be a collective responsibility. If it might have just been in the one department of lighting or something, you might be able to say, well, hang on, those people seem to be in some kind of corrupt relationship.
Yeah. And I know the sun's beaming in on you on that side, and I don't know what we can do about it.
It's divine inspiration.
It's a divine. He's got a halo around him, which I haven't got. So
that's clear.
We can see the clear distinction between who's got the halo and who hasn't. Similar, I'm moving on, similar to team misconduct, it's a similar concept, but it's very different. In a strike context, there's often an occasion in a strike context where violence occurs, and there's a crowd of employees. Certain members of the crowd commit the violence, and other employees look on and observe. And this notion of common purpose is used to then, obviously, the persons who can be identified and who are individually responsible for the violence, they can be charged for assault or violence, etc. And the term common purpose is used where those people who are part of the group associated with the violence, and I was about to say didn't stop it, but perhaps I'll use those words, but come back to that later. And those employees are then dismissed for common purpose. Let me give you the facts of this case. It's a NUMSA case. It went all the way to the Constitutional Court. It's against Marley Pipe Systems. I'll put the name of the case up shortly. But this was a wage dispute. NUMSA members embarked on an unprotected strike. They gathered at the canteen, waiting to be addressed by the head of HR. He didn't appear. They then went towards his office. He came out, and he was severely assaulted and injured by members of a group. 136 employees were convicted on the basis of common purpose, and 12 employees were individually identified as having perpetrated the assault, and they were all dismissed. The 12 plus the 136. This got to the Labour Court, and the Labour Court said, common purpose, and they are dismissed. It got as far as the Labour Appeal Court, and the Labour Appeal Court agreed that their dismissal, well, only some employees appealed, but that doesn't matter. The principle is that the Labour Appeal Court ruled that common purpose has been established because none of the employees intervened to stop the assault, and should have disassociated themselves in some way from the assault during or after it, as to escape liability. So the Labour Appeal Court here is putting a clear onus on the employees who are present to either stop the assault or to in some way disassociate, show that they're not approving of what's taking place. This goes to the Constitutional Court, and the Constitutional Court has overturned the Labour Appeal Court's conclusions, and it said that the mere presence and watching does not satisfy the requirements for common purpose, that there's got to be evidence that individual employees, so what I'm saying, there's got to be evidence that individual employees in some form associated themselves with the violence before it commenced or even after it ended. Employees cannot be required to intervene to stop the misconduct or disassociate themselves in some way from the misconduct, which they never associated with in the first place. So their mere presence there was not enough. There was no obligation on them to disassociate themselves from the violence or to stop the violence. Individual complicity in committing the acts of violence must be established. So let me just share screen with you and pull up this case. It's a Constitutional Court judgment. It's Mali Pipes Systems, NUMSA. The requirements for common purpose. Evidence that individual employees associate themselves with the violence before or after it had occurred. Presence at the scene is not required to be guilty of common purpose, but presence does not automatically mean that you're guilty. And there's no obligation to disassociate from violence that one is not participating in. So this is a Court judgment on common purpose. And I think Alan, you can comment as well, but the practical outcome of this case is that it's going to be very, very difficult for employers to establish common purpose and to produce evidence that individual employees in a crowd of 30, 40, 50, 60 people individually associated themselves with the violence. I mean, maybe they were singing a song which was, the words were, let's kill the management or something. That would perhaps be evidence. But again, how do you produce evidence? You might have a video, but you've almost got to have evidence that each individual employee has associated him or herself with the violence.
In this case, as I understand, Bruce, 12 people were actually identified as physically beating up.
Correct.
But there were at least 69 or so people surrounding. Is that right? There were.
Yes.
And so at what point does your presence around the people who are assaulting, it seems like you would have to go a long way to establish that common purpose.
So common purpose has not been outlawed. It's there. It's under appropriate circumstances. Action can be taken on the basis of common purpose. But this Concord ruling should be looked at very closely if you're ever contemplating allegations under that heading. Yeah.
So the next case is also a strike law. I think you know that one of the rewards, as it were, or consequences of a union or employees complying with the Labour Relations Act before a strike, in other words, attempting conciliation, waiting on the cooling off period. One of the consequences is that you're not liable for any financial consequences to the strike. So you are insulated from any claims. And in this case, it was exactly that. The employer, in this case, was Massmart, and they claimed 9.4 million from Sakawu for losses incurred during a strike. Now, this was a protected strike. In other words, the union did what the Labour Relations Act requires. It was submitted for conciliation, the waiting period took place, they gave notice of the strike, but during the strike, Bruce, there was criminal activity. Misconduct of a serious kind in this case. And the question, when it came before the Labour Court, the unions argued, no, we, in terms of the Labour Relations Act, we are indemnified. You may not claim from us because it was a protected strike. And in this case, the Labour Court said, no, that's not correct.
Should I call out the name of the case?
Sure. Yeah, so it's this Massmart versus Sakawa case. Unlawful conduct during a protected strike is capable of founding a claim for compensation. And because the attack was on the Labour Court's jurisdiction, this case was basically saying the Labour Court had jurisdiction to consider compensation on the year.
Okay, on a similar vein, looking again at the lawfulness of industrial action, there's a case of involving a protected strike, but there was a picket during a protected strike, which didn't comply with the requirements of the Labour Relations Act. So the strike itself, they've given all, they followed the procedures under the Labour Relations Act, but then a picket was undertaken, which was in breach of the Labour Relations Act. This case involved SACTU, the South African Clothing and Textile Workers Union, versus KZN Marketing. And as I said, the strike was a protected one, but the picket had not followed the principles and the requirements of the Labour Relations Act. There was no picketing rules agreed between the parties, and the CCMA had not imposed picketing rules. So KZN Marketing took the view that the strike was unprotected as a result of the lack of procedure regarding the picket. And they then took disciplinary action against the striking employees for participating in an unlawful strike. They took the view that the unlawful picket rendered the strike unlawful. And the Labour Court said no, and drew a clear distinction between the requirements for a picket and the requirements for a strike. And a picket was not a strike, and said the employer could have taken action against the employees for being in breach of the picketing rules, but they couldn't take action against them for taking part in an unprotected strike, because the strike was a protected strike. I'm not going to pull the case name up, but it's a case that'll be in your bundle. It's SACTU versus KZN Marketing. And the principle there is an unlawful picket could result in misconduct charges being brought, but an unlawful picket does not make the strike an unprotected strike.
Yeah. Earlier on, I talked about employees who are allowed to keep on working past the end of a fixed term contract. Now I want to talk about where a person is allowed to keep on working after the agreed or a normal retirement age. In this case, a person hit 60, which was the agreed or normal retirement age.
Alan's quite interested in this case because he's certainly really gone past the retirement age at work. We're going to have a conversation about that.
So 9 months after his retirement, the employer either wakes up or realizes that, well, there's no evidence really whether it was the reason why 9 months later they said, well, we are now terminating. And the argument raised by this guy was, well, hang on, if you didn't terminate at my retirement age, I'm now in a new contract, and it's unfair dismissal to get rid of me now. That was the idea behind it. And the Labour Court and Labour Appeal Court reached the decision that as soon as you've reached the retirement age, termination at any stage thereafter is a fair termination. It doesn't become an unfair dismissal. It's the next case. Yeah. So in section 187(2), the right to dismiss based on age arises at the retirement age and can be exercised at any time thereafter. So but there are cases, I was telling Bruce, where the employer very deliberately enters into a new contract, often where they want some mentoring or some kind of extra specialized service on the person who's retiring. I think that things could be done if there's another fixed term contract agreed.
Yeah, so it does depend on the facts of
Yeah,
each
yeah,
case. Okay. Yeah, we're talking here about ex-employees, as you can see. And the next case, which I want to chat to you about, is whether an ex-employee can bring an unfair labor practice claim under the Labour Relations Act. As you know, the definition of an unfair labor practice talks about unfair conduct between an employer and an employee. So it's quite a limited definition under the definition of an unfair labor practice under the Labour Relations Act. And here you had ex-employees whose employment had ended with this particular organization. It happened to be the Transport Pension Fund. I'm not going to give you the facts of this case. It was a High Court case that ended up in the Constitutional Court, but the principle is important as opposed to what the facts are. But this was quite a complicated case with ex-employees who suddenly woke up to the fact that they had been penalized unfairly whilst they were employed. And they brought an unfair labor practice action. And one of the several defenses raised was, well, you are no longer an employee, and the definition of an unfair labor practice is unfair conduct between an employee and the employer. And that argument was accepted in various courts, but the Constitutional Court ultimately said that, and I'll try and draw up the slide for you. It's this Pretorius versus Transport Pension Fund case. Unfair labor practice extends beyond termination of employment, and these employees. So the learning here is, as an employer, those of you who are an employer, ex-employees can claim unfair labor practices in respect of previous periods during which they were employed by the organization.
So we come to our last case, and this
is the last case.
It is, yeah.
We've got quite fast through these cases.
And it actually deals with, at what point does an arbitrator go beyond this neutral role that we expect of a commissioner or an arbitrator? And we both arbitrated, so we know there's this real tension between offering what is called the helping hand, which some labor court cases have said arbitrators must offer a helping hand, particularly to people who come there who are not skilled, don't understand the law, don't understand that you've got to cross-examine evidence and so on. And so there's a real role for the arbitrator to guide. But there's also a line where an arbitrator can what's called enter into the arena in an unfair way, stop trying to run the case. And this last case, it's a Saldanha Bay local municipality case. The arbitrator took a real role in disallowing certain evidence, cross-examining, and so on. And it went to the point where the one party believed that there was bias. And in our law, it's not, you don't have to prove a person is biased, but they've got to have the appearance of being biased. That's enough. And this case established this principle. I don't know if you want to call this up, Bruce. And it's basically, this is the principle. An arbitrator disallowing questioning or interfering with cross-examinations is an irregularity. If this deprives a party of a fair hearing, it will be reviewable. And the remedy, of course, the Labour Court might say, hang on, that went too far. It's got to send it back for a new arbitration. So it's quite a frustrating thing. Yes, you're setting aside one arbitrator's decision, but you're going to have to go through it all again.
I mean, as you know, the Labour Relations Act gives arbitrators a very wide discretion as to how they're going to conduct a process. And you might know that they're sort of largely two words that describe different approaches adopted by arbitrators. The inquisitorial approach, where the adjudicator to a certain extent enters the arena, asks questions of the parties, asks questions of witnesses and so on, and the accusatorial approach, which is a more hands-off neutral role where you just depend on the parties to present their versions before you, and you decide the case on the basis of the evidence that's been led by both parties. And certainly previous judgments of the Labour Court now have gone both ways. So if an arbitrator doesn't intervene enough, particularly when parties don't have lawyers present, the courts have said there's a clear onus on arbitrators to intervene appropriately to ensure parties understand their rights and how to exercise their rights. So this notion of lending a helping hand. But again, this judgment talks about an arbitrator who's gone too far.
Yeah.
He might be watching. He's a work law subscriber and arbitrator. I had a conversation with him last weekend where he said he now turns off the tape and he says, I'll turn the tape back on when you tell me something interesting. You can judge for yourself whether you think that's a fair or unfair approach by the arbitrator. But there's clearly a thin line that arbitrators need to be careful of either not intervening enough or perhaps intervening too much. And they've got to get the balance right. Intervene enough to ensure that parties are able to present their case, particularly parties have never been in an arbitration in their lives before, but they're able to put their case forward as best they can, but not interfering too much in a way that's biased in favor of one party or the other. So those are the cases, and those are the amendments to Labour legislation which we wanted to cover. So that's the end of our material. Let's look at some of the questions that have come up. Ellen, can you read those?
In terms of the CCMA rule changes, what happens when the respondent does not show up for the arbitration? Are there any changes to this effect? Are you answering that?
I can try. Well, a party would still have to prove its case. I haven't got the rules in front of me, but I think those rule changes spoke specifically about a commissioner's obligation to attempt to find out where the referring party is, perhaps making a phone call.
Yeah.
I don't think that obligation extends to the respondents.
Yeah.
And so a party would still have to prove their case, lead evidence, which obviously is a much easier thing to do if the other party isn't present, but they've still got to prove their case before the commissioner.
Sure.
And it would effectively result in a default award being made in the absence of a party. As you know, then, is it section 144 of the Labour Relations Act? The party who may never have been informed of the date can make application to rescind that award made in their absence, where they can prove that they were never informed.
Yeah.
Okay. Let's go back. I think we've answered that question then.
What is regarded as relevant or acceptable reason for not attending arbitration? I think physical health must be
sickness. Obviously.
Yeah.
A death in the immediate family. I must tell you, when I don't arbitrate anymore, but when I arbitrated, I would invariably grant a postponement on the first occasion. So parties did not have to go that far to persuade me why I should, on the first occasion, postpone a matter. They might have just found a potential witness who they hadn't had a chance to talk to. But what you want to avoid is avoiding matters just being postponed on and on and on. And I know CCMA cases are different because it involves public purse being expended. So I think you do have to have good reasons to ask for a postponement. But I think it would depend on the facts of each case. Sickness and the unavailability of a particular witness who is out the country, death in the immediate family, those kind of factors would certainly. But I don't think the fact that you're busy, that you've got a meeting to attend, I don't think that would be good enough reason.
Yeah.
Yeah, I hope we've answered that.
Condemnations. Can the arbitrator now extend the life of a case even though there's no condemnation application submitted? at what stage would the case be dismissed then?
Yeah, so what I was trying to say is that previously there was a requirement to have a formal condonation application. It would now seem, and I mean, these rules have only just come in, so one waits to see how they're applied in practice. But as I understand it, the commissioner dealing with the case can then say to the party who's impaired, but you're out of time. You've come before me. You haven't lodged a formal donation application. What are your reasons for bringing this case late? And effectively deal with the matter informally there and then at the inquiry, without the need for a formal condonation application.
Yeah.
So the employer, who's normally the respondent, whereas previously you could say, but there's no formal application, you must, that was what the rules said previously, you must dismiss this matter. Now the commissioner has a much wider discretion to, despite the fact that there wasn't a formal application made, to deal with it there and then at the the arbitration.
Yeah.
So yeah, it would, and then it would depend on why, well, the normal factors that you would cover in a formal application: how late you are, your reasons of lateness, the extent of the lateness, your prospects of success in the matter.
Yeah.
Are there any more?
Yeah. Sexual harassment is a sensitive matter. How do you deal with hearsay without evidence or witness?
Well, Alan, you can comment.
So hearsay evidence is where the principal witness isn't available. The hearsay evidence is allowed as an exceptional circumstance when, for example, that person could be outside the country. But hearsay evidence is weak evidence because you can't cross-examine it. So in a sexual harassment case, I think the chairperson would have to be very wary of allowing or taking into account hearsay evidence in a matter as delicate as sexual harassment.
I agree with you. I mean, hearsay evidence, when you deal with evidence, we simplify it down to two steps. Is it admissible? In other words, is it allowed in? Is it allowed to be taken into account? And then if it is, how much weight do you attach to it? And it would probably get past the first hurdle.
Yeah.
But then may well fall down at the second hurdle, because you've got direct evidence which is cancelling out the hearsay evidence potentially. But can I also say that there are accepted variations to procedural fairness in many cases involving sexual harassment, where you can protect the identity of a witness, or the witness doesn't give evidence in the presence of the alleged harasser. And those variations can be allowed in appropriate circumstances.
So I think what's behind this question, Bruce, is this very difficult thing. The employer, in terms of the new code, must be seen to be doing all that is practicable. And often that is having a disciplinary inquiry. And then it's a he said, she said matter. I think if the employer doesn't have any evidence except for the complainant, and there's a vigorous rejection of that by the defendant employee, has the employer proved the matter on a balance of probabilities? Well, the disciplinary chair has got to do that, has got to make a call. And it might
based on the evidence led by those two witnesses.
Yeah. And it's all the things with credibility and so on that come into the reasonableness of the evidence, the likelihood, and so on. So it really is a very difficult thing for employers to meet the requirement of doing all that is practicable.
Yeah, it's not a strict reliability test, Section 60. So the fact that there's been harassment does not in itself make the employer liable. Section 60 makes it clear that if you do everything that's reasonably practicable to attempt to prevent the harassment or to minimize the harassment, then you escape liability. It's only where the employer, and we put up that slide during the presentation, those 7 points, to try and identify, and those were drawn from the cases. And if you go onto work law under harassment, you'll see all the number of cases we just put up some by way of examples in this presentation.
Yeah.
But you can then draw out the principles where, and it's invariably that the employer didn't act fast enough, didn't take action to help the employee who'd been harassed, favored the one version over the other when the facts didn't substantiate that. Those were the kind of common errors that
there was one case where in fact they swung it right around and they then charged the complainant
for making false allegations.
Yeah, and that really set the employer up to have to pay quite a big amount of compensation.
And there's also a case, I mean, just giving those to try and help you identify when Section 60 kicks in, but there's a case where an employee was smacked on the bum by a manager as she walked past. And can I say, in that case, she would have accepted an apology. And so she would have, if an apology had been given, that would probably have been the end of the matter at the time. But no, the alleged smacker said he didn't do it. And the manager dealing with that case said to the employee, well, it's not like you were raped, which is clearly a highly inappropriate comment to make to someone who feels that they've been harassed. And that played quite a large part in why compensation was awarded in that case.
Yeah.
More questions?
Okay. You've said correctly, in my view, that fixed-term contracts seem to be the way many employers do things these days. That is clearly a form of non-standard work. Is that not contrary to what the Concord said back in 2000 in the Nahabu versus UCT case, where it stated that security of employment is a core value of the RA, the Labour Relations Act? Well, I think you're spot on. I think there are some situations where fixed-term contract is legitimate. Strangely, I think, but I think it's fact-specific. But I think fixed-term contracts are used as a way for the employer to test the employee. Is that right?
Yeah. I mean, obviously there are the limitations. I think it's section 200. Yeah. 200B, is it? I can't remember which subsection, but for fixed-term contracts for those employees earning under the BCA threshold, there's got to be a justifiable reason. Yeah. And those reasons are spelled out in the Labour Relations Act. So fixed-term contracts of more than 3 months, where there's no justifiable reason, may well result in those employees being deemed to be permanent employees. Yeah. Those same limitations don't apply to employees earning above the threshold. Yeah. But there should still be a justifiable reason why a fixed-term contract is in place, because otherwise what happens, and this is what does happen in many cases for more senior employees, those contracts get rolled. And ultimately there's the creation of a reasonable expectation of a continued employment beyond the fixed-term contract, which then does end up in the employee being regarded as having been dismissed and not the expiry of a fixed-term contract.
One of the justifiable reasons which has come up in a recent case was that the employee knew that it was dependent on continued funding by a sponsor. Yeah. And I come from a university background, and that was, so many posts were as a result of project financing for that particular research project. And so sometimes, I mean, it contradicts you. You can't correct by the Naharu case, where security of employment is the desired norm, but there are going to be circumstances when I think that justify a fixed-term contract.
I apologize again for Alan's halo. It slips.
You can notice that I hope there's more inspiration for Bruce. His answers are going to get better and better now.
All right.
Okay. Do you expect that this case might be taken to the next level?
Sorry, Jeff, I'm not sure what case you were talking about, but maybe send us you then ask a question, the next question, but you can email us if you want to ask us about that case and tell us what the case is, and we'll comment back to you on that.
The next question is, what would be the employee's right to call witnesses if there's no formal inquiry? Or would the employee be expected to submit such evidence or witness as well? Okay, let's assume that both these refer to the Bitcoin case, where the employer just used this very abbreviated procedure. What would be the position if there was no witnesses? I think I want to repeat the point I made, that a fuller hearing is more likely to demonstrate the correctness, the truth of the matter.
Absolutely.
Yeah.
And if you're appointed as the internal chair, well, to decide the case on written representations, what do you do when there are direct disputes of fact? This person's saying this in writing, that person is saying that. You haven't had a chance of hearing the evidence, of looking at the witness, observing how dependable their evidence may or may not be, and giving their versions. So while that case confirms that if an employer has a policy that complies with the Code of Good Practice, that is not unfair. I mean, to be honest, we would love to rewrite that Code of Good Practice. We think it could be a far better written Code of Good Practice, the unfair dismissal one, and give far greater guidance to parties as to how they should.
But I think behind Jeff's question, he's asking, is that case going to be taken further? You never know. It was an acting judge, and sometimes acting judges are tested by the matter being taken on appeal. But gentlemen, you commenting on something. I'm seeing more and more in the popular press and in cases of the employer simply saying, give us reasons why you should not be dismissed for X. And the employee has got to then, they've got to provide reasons why they shouldn't be employed, or why they should not be dismissed, I mean.
Yeah.
So it seems to be a managerial tactic being used quite a lot.
Okay.
Next one, does the sector of the employer's operation not matter? i.e. would we on transport? Oh, so this is referring back to the changes to the Employment Equity Act. I just don't know the answer. It seems as if some sectors are already being talked to by the departments. So I don't know. Do you know anything?
Well, I mean, it certainly is sector specific, the targets.
There's no hint that any sector would be exempt.
Yeah.
Do the changes in CCMA rules regards condonation impact on bargaining council's procedures as well?
I don't know the answer to that legally, but I think many bargaining councils, as I understand it, have just adopted the CCMA's rules as their method of operation.
That's right. They do.
So I don't think that they automatically legally apply. So bargaining councils would have to decide for themselves whether to continue to be guided by the CCMA rules or not.
It would have to be a conscious decision by the bargaining council to adopt the new rules.
Yes.
Yeah.
Yeah.
Can the specialist investigator speak on behalf of the staff who wish to remain anonymous under the tip-offs? Okay, that's an interesting question. Doesn't really relate to any of our cases, does it? But maybe that cash bills case.
You're talking about whistleblower.
Yeah.
Okay, well, you can comment on that. It's not a topic that I.
Can the specialist investigator speak on behalf of the staff who wish to remain anonymous under the tip-offs rules? Okay.
I don't know the answer to that. Is that under the Whistleblowing Act?
Yes, but I'm not recalling a section that deals with this. You've got the right to remain anonymous. We're going to have to answer you in an email, I think.
Okay, Ayesha will come back to you on that.
The next one. Are the involved parties allowed to raise an objection to the other party's witnesses in relation to seniority? Okay. Many disciplinary procedures have got requirements that certain people be senior. Like the chairperson must be certain number of grades or levels higher than the person charged. And there are these regulations, particularly, I think, in government and municipal procedures. And I think the purpose is that someone who's high up the hierarchy is the chairperson and the investigator. But
yeah, I mean, I just think at a practical level, if the chairperson is required to decide on evidence and there's a more senior person than him or her giving evidence, it just puts unbearable pressure on that person. So I would always advocate that the chairperson should be the most senior person involved, who is involved in the matter either as a witness or
what about the investigator having to cross-examine someone quite senior? Is that also compromising?
It may be, but I mean, certainly the chairperson should not assume that a more senior person is telling the truth and a less senior person's the one who's not telling the truth. I mean, clearly that would be an inherent bias that would be unfair.
Yeah.
But yeah, someone to be an investigator in a case, to be leading management's case, and they've got to challenge the evidence of someone across the room. It may be very difficult for them to do that if the person is a more senior person in the organization.
Okay. Can the employee demand permanent employment if the employer has been reviewing the fixed term contract for the past 8 years or so? What would be the reason of an employer not to offer permanent employment?
I mean, each of these cases do depend on the facts of each case, okay? And I mean, it is conceivable that there have been 8 renewals of the contract, each time based on additional funding, using the example that you've given, and where the employer in each case has gone out of its way to ensure that there's not any expectation of employment beyond the period of the further fixed term. But in general terms, where contracts have been rolled in this way, it often leads to a conclusion that there is an expectation of continued employment.
Yeah.
It does depend on the facts of each case.
For the person who's trapped in a fixed term contract, how do they challenge that? Is it an unfair labor practice? Surely it's only their right to challenge this only arises when the contract's not renewed, because that's what the Labour Relations Act says is a dismissal.
A dismissal, yes.
But while you're in the contract, I'm not too sure how you're going to frame your dispute.
Yeah.
So I think that's one of the problems. It's maybe you could file a grievance.
Well, if you're on a fixed term contract and then don't get all the benefits that permanent employees are getting, then I mean, that might fall into the unfair labor practice
or even
jurisdiction.
Or even equal pay for equal work.
Equal pay for equal work under the Employment Equity Act.
Section 6(4) of the Employment Equity Act.
Yeah. Gee, I do apologize for the light that's on our screen. We must remember to not have or use this venue if we're going to have this date for next year's webinar. I wasn't aware of that.
Okay. The case if a formal inquiry is not held.
Well, I think we've covered that.
Well, I think the law has been saying you can have an inquiry must be held, but it can be informal. But the question is, if a formal inquiry is not held, you can get away with the informal inquiry. Yeah.
Yeah. Tanya from Tokiso is saying that Tokiso has its own rules for statutory cases. We will review our rules to align with the new CCMA rules and publish them on our website next week. So those of you who are working with Tokiso, that's news to you. Can I just also say that under the harassment code, there is often a need for some investigation, or there might be an informal procedure adopted where you have a mediated approach. Takiso is ideally placed to provide these services. So if you're looking for the services of an outside agency and they've got experienced people, they've got good people who can help you with these investigations into harassment and into following formal or informal procedures under the new code. So they're the people to contact if you need outside help.
The aggrieved employee argues that his Section 9 manager has got no right to talk to HR document in the hearing, but HR member must be invited to talk to such document.
Well, that would depend on the facts of each case. I mean, if someone is aware of a policy, I mean, HR often is called as a witness to testify to that policy.
Yeah.
But I'm not sure what would be in dispute. Is it disputed that the policy exists? If it's disputed that the policy was communicated to all employees, well, the person who did that would have to be called to give first-hand evidence of how and when it was distributed.
But I think the way you've asked the question, I can't believe that there's someone has got no right to talk to a policy. A manager might not know the full extent of an HR document, but you couldn't say to you can't speak about this at all.
No.
Yeah.
I mean, certainly there, again, we spoke about evidence being admissible and then how much weight to attach to it. It would certainly be admissible for any manager to talk to a policy. How much weight you attach to it would depend on what the person knows.
Yeah.
I think that's all the questions.
Yeah.
So just to end off, thank you, those of you who are still tuned in. There are a large number of you who still are. We appreciate your attendance. We hope you found this worthwhile. Please give us feedback if there are issues that you liked or you haven't liked about this presentation. Help us improve them for future webinars. We will try and avoid halos and sun beating in on us, and we did have a few technical challenges where the share screen function worked sometimes and didn't work sometimes, so I apologize about that. But thanks for your attendance and enjoy the rest of your day. Thanks. Any other comments, Alan?
No, cheers.
Happy.
Thank you.